in the WIPS, to professors for accepting to comment on my paper, and to all of you for being here. As you know, I'm not a genius like Kenneth, but I make my best effort. I'm just gonna talk about the first half of my paper because the second one is a bit technical on arbitration and it could be a little bit boring. Parties in an international arbitration always want neutrality. If a Chinese corporation has an arbitration with a Brazilian corporation, they will not choose China or Brazil as the seat of the arbitration. They will choose a neutral forum. Parties may agree, for instance, Belgium as the seat of the arbitration. The seat of the arbitration is fundamental, it's essential, because it determines the law of arbitration that will govern the procedure. Catherine Royer has stated that in the marketplace for international arbitration, competition is everywhere. And it is undeniable that states compete in order to be designated as arbitral seats. And in order to be designated, some states, as we will see, have taken crazy decisions. As you know, in arbitration, appeal doesn't exist. There is only something that is called recourse of annulment that can be filed in cases in which something really serious happened. For instance, when it is discovered that one of the arbitrators acted with corruption. Today, all the countries of the world, all of them, count with a recourse of annulment. In 1985, however, Belgium took a crazy decision. It eliminated the recourse of annulment from its law of arbitration. From that moment on, arbitration in Belgium was one shot with no control. The Belgian legislator naively believed that through this measure, Belgium, the arbitral procedures in Belgium would be faster, would culminate faster, and therefore Belgium would become an attractive arbitral seat. Nevertheless, the result was completely the opposite, and dramatically so. The number of arbitrations that were seated in Belgium while this measure was in force could be counted with the fingers of one hand. It was amazing. There were hundreds of arbitrations, and after this measure was adopted, nobody wanted to arbitrate in Belgium. This event was so controversial in the field of international arbitration that it was recounted in books and articles by many of the most important international arbitration specialists. Until now, everyone in the field of international arbitration knows what happened in Belgium, but nobody knows why. My idea is that it happened because the recourse of annulment and recourses in general have a behavioral, have a psychological foundation. And in order to prove it, I will describe two psychological phenomena. First, the necessity to throw tantrums. And second, the necessity of a legal escape hatch. Regarding the first one, I believe that the Belgian legislator forgot that by nature there is a human necessity to throw tantrums. We've all seen people complaining against unfairness and arbitrariness. We have seen workers striking when they believe that their employers are committing abuses. We have all seen citizens marching when they believe that the government is committing abuses. We have even seen children throwing tantrums when they believe they are being treated unfairly. Whether real or perceived, arbitrariness provokes reactions of recourse and defiance. This has been well illustrated in an experiment conducted by Franz de Waals called Monkeys for Equal Pay. Let's see briefly the experiment. You can hear, right? Oh, no.
You have the volume over there. It's in the middle.
I'm not really technological. Do you know where is it?
Next to the forward?
No,
in the computer.
In the YouTube video, there's
Go to the computer.
where it says sound.
My laptop?
Yes.
Yeah, but it's in the maximum.
No.
Okay, I understand. Yeah. Sorry.
Them cucumber for the task, the two monkeys side by side, they're perfectly willing to do this 25 times in a row. So cucumber, even though it's really only water in my opinion, but cucumber is perfectly fine for them. Now if you give the part the grapes, the food preferences of my capuchin monkeys correspond exactly with the prices in the supermarket. And so if you give them grapes, it's a far better food, then you create inequity between them. So that's the experiment we did. Recently, we videotaped it with new monkeys who had never done the task, thinking that maybe they would have a stronger reaction, and that turned out to be right. The one on the left is the monkey who gets cucumber. The one on the right is the one who gets grapes. The one who gets cucumber, note that the first piece of cucumber is perfectly fine. The first piece she eats. Then she sees the other one get a grape, and you will see what happens. So she gives a rock to us, that's the task. And we give her a piece of cucumber, and she eats it. The other one needs to give a rock to us. And that's what she does. And she gets a grape. And she eats it. The other one sees that. She gives a rock to us now. Gets again cucumber.
Justice with the heavy small.
She tests the rock now against the wall. She needs to give it to us. And she gets cucumber again. So this is basically the Wall Street protest that you see here.
So this aversion to arbitrariness has been found in chimpanzees and dogs as well, and it occurs, of course, among people. It is my view that this drive to oppose arbitrariness underlies the dispute resolution system. This leads people to rebel against the fit and always demand mechanisms of control. This explains why the abolishment of the recourse of annulment in Belgium scared away everyone, obviously because it is not attractive to arbitrate in an arbitral seat where corruption or abuse of power cannot be controlled. People psychologically need mechanisms of control. And the second psychological phenomenon that explains the behavioral and psychological foundation of the recourse of annulment is the necessity of a legal escape hatch. And this is actually Professor Ayer's idea, so I wanted to say this. And this could be appreciated in the film The Right Stuff. This movie concerns test pilots of the Mercury project, which was an effort to send American pilots for the first time to the space. Let's see a very small part of the movie.
There's no window. No window. What about the hatch? The hatch? Yeah, the hatch. We need a hatch with explosive bolts that we can open ourselves. I think there's something to Excuse me, below,
Now that's where the hatch with explosive bolts goes.
the hatch with the explosive. Yeah, there could be a hatch with explosive bolts on the capsule.
That is a spacecraft, sir. We do not refer to it as a capsule. Spacecraft.
Yeah, a hatch with explosive bolts on the spacecraft. There. And there will be pigeon yaw thrusters, which will enable the astronaut occupant to pilot.
Astronaut, pilot.
Yeah, the astronaut pilot. To have some, to have
Control.
control.
By demanding an escape hatch, the pilots were trying to increase the feeling of control in a critical situation. The hatch, however, not only provided with control, but also with trust and hope. It made the pilots feel that even in an adverse scenario, not everything was lost. I argue that the recourse of annulment complies an analogous function in an arbitral proceeding. By having the annulment at their disposal, whether real or perceived, the parties feel they have an additional measure of control over a dispute, since they have the possibility, the last opportunity, to reverse an adverse decision. Even though the setting aside, the recourse of annulment does not increase parties' chances of winning the case, at least having the annulment at their disposal has a calming effect. That is why, metaphorically, I believe that the recourse of annulment is a legal escape hatch. Now, to conclude, should the recourse of annulment exist solely for psychological reasons? The answer is no. In a state governed by the rule of law, I believe that control of power is an essential element. It is my view that it is not possible to it is not possible to affirm that a state is democratic if control of power is not enforced. In arbitration, parties bestow jurisdiction to the arbitrators, granting them the power to resolve their disputes with res judicata effects. Having absolute freedom to resolve a dispute is inadmissible in a democratic state, since it would open the door to arbitrariness. In conclusion, I believe that the recourse of annulment and recourses in general are fundamental, not only because they satisfy this psychological need to throw tantrums, but also because they are democratic tools that ensure control of power. Thank you very much.
So this Belgian law, so good presentation, good paper. The Belgian law 1717, it was one of the commentators that you quote characterized it as a completely laissez-faire system that would quote unquote, and that it was not, because it didn't allow the parties to contractually decide whether or not they wanted to have the annulment action possibility. It was I believe it was a mandatory rule, and so a lot of your paper is right now an argument of why a mandatory rule that 1717 was a bad law, but it opens up the question, okay, we don't want it to be mandatory, but what is the better default? And that there are many states that have merely a default, and what are the appropriate altering rules? Does default choice matter? In this case, are among the sophisticated parties, would default matter to the amount of business that was brought in? It also, on this issue, it would be interesting to know a little bit more about how 1770 was brought in. You've convinced me, yes, they thought it would create more business, but were arbitrators consulted or in favor of this? Were they crazy or naive, the legislators that introduced it? No. They cause you to cry? No. They have many layers. And so onions have many attributes, and often when you're using a metaphor, you have one in your mind, but you may not be in control of what the readers take from it. And so I'm worried that, like the onion metaphor, the tantrum metaphor, kids that are having a tantrum have a loss of control. And in fact, one interesting connection between the tantrum metaphor and the escape hatch metaphor, the escape hatch is about the illusion of additional control, and the tantrum is about loss of your own control, which can be cathartic. But it could also be about trying to protest in order to get a substantively different outcome. And or it could be just, I need to have my day in a public jurisdiction. I have to have my day in court where I can say that I've been wronged publicly. Those are three different things that might be going on here, and it's not clear to me that which of these are going on. And it's in my household, as soon as a child threw a tantrum, they immediately lost any chance of getting what they wanted, even if it was an otherwise valid claim, because you could never have a tantrum win. And so to me, this idea of this would be, if this really were a tantrum, the court should never even consider substantively annulling the decision. That would be, it raises a question, turning to the personal, of asking your parents whether you had what were your tantrums like, and have you had exposure to tantrums through siblings or family members, okay. So next, let's turn to the escape hatch. As I say, this is about wanting to have increased control. I might play up more about whether it's an illusion or actual control. It's one of the reasons it may be a kind of false consciousness, because the option can have negative value. In another part of this, this was foreshadowing of an astronaut using the phrase "screwed the pooch," and inappropriately, inadvisedly hit the escape hatch, and it caused the craft to sink when it need not have, because he panicked and hit the. And I had a friend of my dad didn't wear seatbelts because he wanted more control to be able to jump out of the car if he was about to be in an accident, and that is a kind of an escape hatch that. And I remember being like 12, and he was saying, no, a seatbelt is an anti-escape hatch thing. In your escape hatch section, you also discuss this Markovitz idea of the annulment as a kind of insurance, as another way of keeping control in an insurance sense. But it's only going to provide people with insurance if they think the judge is sufficiently unbiased, or is likely to reduce a particular the type 1 or type 2 errors that hurts you. There could be appellate judges where you think that does more harm than good being before them. There is, and it raises the possibility to me of asymmetric waivers of annulment. That the parties might say, look, given the possible biases of arbitrators and or appellate judges, we'll let plaintiff have annulment right, but not the defendant. And then turning to this political foundation, your point, I thought it was that this was theoretically a bit vague. One of the things that I think you're doing is you're first trying to explain why there is a arbitrance demand the annulment right, and both the Tantrum and the Hatch theory are about the arbitrance demand for an annulment right of cause of action. But the legal political foundation point is more about why the state would demand it, and it's this. You don't really confront the fact that there are a whole bunch of states that you talk about that have just merely defaults, so they don't demand it enough that they've made it mandatory. And you say that delegated power must have some system of control, and I wonder whether other controls might be possible besides this. Instead of the annulment cause of action, you might be able to impeach, have the equivalent of impeachment of arbitrators so that they never could work again if they were found to have done this. And there are just many other circumstances where in sports leagues, you never are able to have an annulment of a game once it is called. In the vast majority of professional sports leagues, it never happens, even if there was a demonstrably bad refereeing. Even if there was fixed games, they don't change well, at any rate. So I think that to me it's, and I don't understand why you tie it necessarily to democracy, that democracies stop appeals and have final judgments, and the demos decided to delegate it without this. I don't see how that is necessarily inconsistent. And frankly, this part of your argument sounds a little bit like Donald Trump when he says you can't have a country without a wall. You can't have a democracy without an annulment right. I think you can have leaky buckets that still carry some water. And on this political foundation, though, I thought you could do a lot more positively with the fact that the Belgian law and the Swiss law treat wholly foreign arbitrants differently than those that are domestic. And so that seems to me to be consistent with your theory that, why do I care about how these foreigners, I don't have to give them annulment rights, but anybody who's actually touching and concerning my land, I feel like they need to have one. So that's something that you could, I think, affirmatively play up more. And the last biggish point is expositional. I think you have way too many quotations of statutes and scholars. And these are long paragraph quotations of scholars, and I think many of them could be, the statute stuff could be moved to a web appendix, and you could just keep that, you could keep the summary table and describe that a bit more. That would save thing, and I'd paraphrase a lot of the quotations of scholars. I'd sure cite to them, but paraphrase them, that could be tightened up a lot. And expositionally, so you have too much of those quotations of statutes and scholars, but you have missing exposition about the basics, arbitration basics. You did better in this presentation, said the seat of the arbitration means this. You didn't lay that out, okay? And I know a little bit about arbitration, but not so much about international, and it was really hard for me because I don't know. You talk about country of origin sometimes. You talk about domestic versus international arbitration, seat of arbitration. I don't know what, I'm only kind of like, are these the same things, different distinctions that are being made here? And I wanted to know more another sentence or two about the difference between bringing making a challenge in an enforcement proceeding as opposed to a setting aside proceeding. I didn't quite get why an enforcement proceeding isn't sufficient to control. I have a sense that it's related to the fact that enforcement is going to go on in multiple jurisdictions where the annulment proceeding is just in the seat. But you're making me work too hard to figure out that basic implication. So this is an expositional set of things. Don't make it so hard on somebody like me. I'm not sure the short section on investment arbitrations was worthwhile to keep it expositionally, and we're moving towards smaller points. But my last expositional one is the bullet point narratives of the conclusion. I would make more narrative and less Wittgensteinian in the way you frame them. And then just three more small points. I would want to know more about what these states that allow partial waiver, what partial waiver is. Is it inconsistent with democratic control? You might want, in thinking about the kinds of things that could lead to annulment, you might distinguish between what's arbitrary and capricious. Random assignment is arbitrary but not capricious, and I didn't. You do talk about injustice and bribery and collusion, but I didn't. Manifest disregard didn't make it in there, and I'm just since that's a basis in the United States, I was surprised not to see that. And the last point is just a view here of how many rounds of review do you think are sufficient to satisfy the political democratic demands? Because whenever you get to that last judge for which there's no more annulment, if that judge rules against you, well, I paid that judge $1 million and no tantrums, no escape hatches, no political control. That's and there's always going to be a final judge, and so why is putting it down to why is having one solve all the problems? But the number of appeals, I would have liked more on that. Good job.